I'm actually going to give Jen control, the host control. That's what it says on my notes here. I didn't see that part.
That sounds great.
Thank you.
No problem. I'm going to make sure the meeting goes off fine and then give you control about 10 minutes into it.
Sounds good. Thank you.
Good evening. Do we know who we're waiting for?
Eileen Cena, I'm not sure if she's on, and is it Carol Primavera?
Do we have contact information for either one of those people?
John, I only have their email addresses, no phone contacts. I don't know if any of the board members do.
And Eileen is she the tenants rep for Leisure Woods? Is that correct? Oh, I'm sorry. You are Sue. My mistake.
She's a Rockland resident.
Okay, and Carol is one of the owners' representatives, right?
That's correct. I have Eileen's number. Do you want me to call her?
Yeah, please.
Who is she representing? We have Susan and we have Cassie.
She represents the town of Rockland.
Oh, okay, cool. Thank you. I'm sorry.
That's okay. Jen, would it be possible for you to email her the link? Eileen,
Sure.
I wasn't aware of tonight's meeting.
Well, it appears we had 5. That may be the best we can do, right? The first order of business on tonight's agenda is actually to organize, name a chairman and a clerk. I don't know if any members of the board wish to make a motion to name a chair.
I don't know if she's interested, but I'd like to nominate Deb Roby for chair. I think she has the best experience among those of us here on the board.
Is there a second to that motion?
I'll second the motion.
All in favor of giving Deb the thankless job as chair? I think we need to probably, do it by roll call. Brian Kane,
Yes.
Eileen Sina. I think you're muted, Eileen. Casey Kidd,
Yes.
Sue Sullivan,
Yes.
and Deb Roby.
Yes, I accept.
Okay, Deb.
Thank you, Deb.
Do you want to name a vice chair, just in case Deb is not here? And we're inclined. And Deb, I'll turn it over to you since you are the chair now.
Okay. Can I do nominating or does that go to other people?
You can nominate.
I would like to nominate Sue Sullivan.
Is there a second?
I'll second that.
Okay, all in favor, if we can call that out.
All in favor? Okay.
Aye.
All right, looks good.
Aye.
I guess finally, we should name a clerk who'd be responsible for making sure minutes are done.
I am not sure. Brian, are you interested?
I prefer not.
Okay.
Yeah.
Would anyone want to volunteer? Eileen?
Well, this is my first experience on any board, so I'm hesitant to accept it.
Okay, Casey?
If no one else is
Yeah, it
accepting
looks
it.
like we have only a few people, so.
And Jen and I can help with
Okay.
minutes just to make it clear what you have to include, what you don't. It really doesn't have to be all that detailed, all that long. So hopefully it's not too big a chore. You don't have to do word for word minutes. That's important. And so I think Casey was,
Casey was my last request.
Is there a second?
Unless anyone else wants to jump in. No. Second for Casey?
Second,
I'll accept.
I'll
for-
second it, yeah.
Okay.
Oh.
All right. So we have,
All in favor?
I,
aye,
thank you, Case.
So the next item on the agenda, Madam Chair, is the certificates for eviction.
okay, so, I think Mr. Laverty is going to go through those, or?
Yes.
Good evening, Madam Chairman and other members of the Rent Control Board. My name is Mark Laverty. I'm the attorney for Hillcrest. We have before the board tonight 10 certificates of eviction. And I just want to make it clear to the board and to anyone listening that we've requested a certificate of eviction, but that does not mean that if the board issues the certificate of eviction, that a tenant actually gets evicted. It's really only allows the landlord to initiate proceedings to begin an eviction process in the housing court. It doesn't mean that somebody's evicted. It only gives the landlord permission to proceed forward with an eviction action in the housing court. And when we go to the housing court, there are many resources right now because of COVID that are available to all residents that are behind on their rent. There's a RAFT program here in Massachusetts, which is state funds to help people with back rent. There's what we call ERAP, which is a federal program that gives people up to 18 months worth of rent if they've been affected by COVID, whether they've been laid off, without a job, family members have been sick, et cetera. So there's really a lot of resources out there to help people if we could just get into the housing court. And I find that most people don't know about some of these programs, or they're even hesitant to apply unless we can get to court. And, you know, a tenant always has a right to defend themselves. The landlord has a right to put forth their case and any claims that he or she may have. So I just want to make it clear, it's not really because you issue the certificate of eviction that somebody gets evicted. It just allows the landlord to initiate the process. So we have 10 before the board tonight. And just as an administrative matter, which I brought up at the last hearing, Miss Casey Kidd is one of the certificates of eviction that the landlord is seeking. So from my perspective, it's a conflict, and she should recuse herself for any of the hearings that are regarding any certificates of eviction before the board.
May I?
Sure.
Mark, thank you for bringing that up. It was a perfect opportunity for me to be able to speak. So I am actually not only recusing myself from the evictions, but I did not pursue a written disclosure form. I'm going to recuse myself from the meeting as a board member entirely, along with the proposed rent increase. I will speak still for myself as a resident. It is a public meeting. I still have access to it, and I will do that. But as far as anything else, I will be recusing myself entirely.
Okay, and I appreciate that. And you most certainly have every right to speak as a resident and a public member. So I have no problems with that.
I'm glad we're on the same page.
Thank you. So in no particular order, I'm just going to go through the certificates of eviction that we requested one by one, and the board can make a decision on each one. I've submitted these documents as we've gone along in this process. So
Can I ask a quick question?
sure.
If the certificate is not granted tonight through the Rent Control Board, how does that affect the ability of the owner to evict?
So
And can people access those resources without an eviction notice?
they can access those resources without an eviction notice. There are many residents at Hillcrest that have gotten behind. The landlord is constantly notifying residents, making phone calls and saying, hey, look at these programs. We can help you with the application, go through the process. And they've been able to get funds. The people that are before the board tonight are those people that have not paid off any rent owed. So before the landlord can go forward under the eviction section or the rent control statute, they have to get the permission from the rent control board. And the burden for the landlord, from my perspective, is relatively low. The statute itself basically says that the owner must provide satisfactory evidence that all notice requirements have been satisfied and the tenant has failed to cure the alleged violation. And it refers to a statute, Mass General Laws, Chapter 140, Section 32J. And that simply means that the landlord has to give the tenant a notice to quit, a 30-day notice to quit for non-payment of rent. It gets served by constable. They have to detail the amount that's owed for non-payment of rent. And then the tenant has a right to cure that notice to quit by paying off the balance anytime before we get to court. So the ones that are before the board tonight are people that have received the appropriate notice to quit, and they haven't completely cleared their balance. In other words, they haven't reached zero. And then that allows the landlord to initiate this process. If the rent control board denies a certificate of eviction, which I don't think they have any discretion to do that, as long as we've met the notice requirement and we can show that the tenant still owes rent, then the landlord would not be able to go forward based upon this notice to quit.
Mr. Laverty, the documentation that I received looks like a lot of these were in arrears as of September of 2021. Are the majority of these people still in arrears?
Yes. So there's some that go back as far as, I think, October of 2020.
Okay. Yes, I did see that.
Yep, there's a lot of those. We've served many notices to quit that have already cured, have paid the balance, or got wrath funds. Right now we have 10. I think we have 2 others that we're in the process of getting ready to submit. But the more recent ones are all smaller balances, but there's many people that have larger balances.
So once they get into the housing court, that is where they absolutely will be notified about, not that they haven't already, but they will be notified about the programs that they can apply for.
Yes, so absolutely. The way the process, and I'll just explain it for everybody here for educational purposes. Since COVID has gone into effect, the housing court and the district courts regarding of eviction actions have created what they call a 2-tiered system. The first step is, once the landlord files the case with the court, they'll notify the tenant of all these resources. They give them an information sheet, who they can reach out to in the court and many of these different agencies, and the links that they can apply. And then it also schedules the case initially for what we call mediation, to sit down with a housing specialist that works for the court and tries to bring the parties together to try to resolve the case without any sort of litigation. And again, they bring up all the resources that are available to them and many different agencies that can assist them. And in that process, they encourage people to apply for a RAFT or ERAFT or different programs. If they do that under Chapter 257, which was enacted because of COVID, the eviction process stops at that point, and it allows the party to continue the case further with the court so that the RAFT application get processed. If the landlord gets all their rent through any of these different programs, they automatically have to dismiss the case. If there's still an outstanding balance, then they're obligated to try to enter into a payment plan with the tenants to try to resolve whatever balance is left. So it's a 2-tiered system. And if the parties can't reach it through these programs and whatnot, they still have a right to have a hearing in front of the judge. Both parties have a right to present their case. It's sometimes that's the only way you can resolve cases is before a judge, but I would say 90% of the cases that I've brought in the last 2 years have all resolved themselves without the need for a trial.
So this decision that we make tonight is just the beginning stages of the process for them to get into housing court. Is that correct?
That is correct. It's just to initiate, the landlord could file an action, and then the court will then serve the tenant and the landlord with the steps as they proceed forward. So it's only the initiation process. The word certificate of eviction is poorly worded, but that's what they use. So a tenant is not automatically evicted. They always have a right to defend themselves.
Okay.
Any other questions? So the first one I have, and I'm gonna try not to use names. I'm just gonna use the addresses. But the first one is 39 Crestview Street in Rockland. So in that case, the landlord, back in October 23rd of 2020, served a 30-day notice to quit for non-payment of rent upon the resident at 39 Crestview Street. It was served by constable, and then at that time, there was an outstanding balance owed of $8,651.46. The landlord has not taken any steps whatsoever to pay any rent or clear the balance. The outstanding balance right now through the end of February is $19,571.41. So it's the landlord's position. They've received the appropriate notice to quit in accordance with the statute, and they have not paid or cured the balance. So we're seeking a certificate of eviction so that we can move forward and file an action in the housing court.
Madam Chair, taking these one by one, I think it would be appropriate for someone on the board to make a motion on each one as they come up and then vote on each one individually.
Okay. Does anyone have a motion to agree?
Yeah, I'll make a motion to.
So we'll make a motion to evict or
Well-
to approve the certification.
Well, is there other option to just vote on it as the 10 submitted as a group? Do we need to vote on them individually?
I would think the most fair way would be to vote individually, but
Okay,
I mean, if
I
anyone else
asked
has,
because we've got all the paperwork, if you will, and the notifications and the timelines. And notifications for this particular meeting actually went out this last summer. So that the reason I was asking was not to be insensitive to anybody, but for expediency. That's all.
yeah, well, I understand that, the reason, but I think some of them may have already, I mean, maybe some of our paperwork is older, and I
Sounds
know
like-
that the amount of that this person has as of February is larger than it was when we received the paperwork initially.
Yeah, obviously. Okay. No.
So Madam Chair,
Yes.
I omitted one step.
Okay,
Now that Attorney Lavie has presented, I think it's 39 Crestview, is that correct?
yes,
We should ask if there's anybody who wishes to be heard on the petition or the certificate for eviction for 39
okay.
Crestview.
okay, I'm sorry.
No, that's
So
my
this-
mistake.
I'm new with this, I'm sorry. So does anyone want to be heard in regards to the 39 Crestview? I don't think anybody is here representing that address.
So now would be appropriate to entertain a motion to approve or deny the certificate.
Okay. So do we have a motion to approve or deny?
I will.
Motion to approve the certificate?
Anyone second that?
I'll second it.
All in favor? Okay,
And just for the record, Ms. Kitty, you're recusing yourself from that one, is that correct? So it's 4 in favor and 1 abstention, is that correct? Or recusal?
Correct.
Okay,
4 in favor and 1 recusal.
okay. Attorney Lavity, the next one.
The next one I have is 33 Crestview Street. And that resident was served a notice to quit back on January 31st of 2021. At the time, they owed the landlord $10,286.95. That 30-day notice to quit for non-payment of rent was served by constable and cured the balance. The outstanding balance to the end of February is $17,319.49. And I'm requesting that the board issue a certificate.
Does anyone have anything they would like to say about that? in,
It's 33
Response.
Crestview Street.
33 Crestview Street. No rebuttal? Could we make a motion to approve or disapprove?
I'll approve.
Anyone second?
1 second.
Okay. All in favor? Okay,
Again, that's 4 in favor and 1 recused.
The third application for a certificate of eviction is for 38 Crestview Street. That resident was served a 30-day notice to quit for non-payment of rent back on January 31st, 2021. At that time, they had an outstanding balance of $7,628.44. They've not made any payments towards that account. The outstanding balance right now through the end of February is $16,842.07. And we're requesting that the board issue a certificate.
okay. Anyone from 38 Crestview Street like to say anything about that? Rebuttal? Okay. The nomination to approve or disapprove?
I'll
Approve.
approve.
Second?
Second.
All in favor? Okay, so that's the same. 4 in favor. And 1 accused.
The fourth matter that I have for the board is 45 Deerridge Street in Rockland. That resident was served a 30-day notice to quit for non-payment of rent back on January 31st, 2021. That tenant had an outstanding balance of $1,649.34. They've made some payments toward the account over time, but they still presently have a balance owed of $9,555.91. And we're requesting that the board issue a certificate of eviction for 45 Deerridge Street.
Okay, anyone from 45 Deerridge Street have anything to say rebutting that eviction notice? Okay, anyone make a motion to approve or disapprove?
I'll approve.
Okay, second? All in favor? Okay.
The next matter that I have before the board is 61 Fairview Street. And that resident was served a notice to quit back on September 14th of 2021. At the time, they had an outstanding balance of $1,364. It was a 30-day notice to quit for non-payment of rent. They've not made any payments towards that account since the notice to quit, and they presently have an outstanding balance to the end of February of $5,027.25, and we're requesting a certificate issue.
Okay, anyone from 61 Fairview have anything to say about that matter? Okay, do we have a motion to approve or disapprove?
Make a motion to approve.
Okay, anyone second?
I'll second that.
Okay, all in favor?
Can I just get clarification? What was that address, Mark?
61 Fairview, am I correct?
Yes. Yep.
Thank you.
Okay, so that was approved.
So the next one I have before the board is 10 Alpine Street. That resident was served with a 30-day notice to quit for non-payment of rent back on July 9th of 2021. At that time, they had an outstanding balance of $2,369.77. They still have an outstanding balance on the account. They have made some payments, but the outstanding balance through the end of February is $2,621.93. And I'm requesting that the board issue a certificate for this resident.
Does anyone from 10 Alpine Street have anything to say, or are they on the meeting? Okay, do we have a motion to approve or disapprove?
I'll
Motion
approve.
to approve.
Yep.
Okay, any second? All in favor? Okay, so that was approved.
The next matter I have before the board for certificate of eviction is 24 Balsam Street. That resident was served with a notice to quit, 30-day notice to quit for non-payment of rent back on September 14th of 2021. At that time, they had an outstanding balance of $1,679.72. They still have an outstanding balance as of this date through the end of February. It is now $3,937.15. And I'm requesting that the board issue a certificate for this household.
Is there anyone from 24 Balsam who would like to comment on this eviction notice? Okay. Can we get a motion in favor or disagree?
I'll make a motion in favor.
I'll second.
Okay, everyone in favor? Ryan?
Sorry, I made the motion.
Okay, so that we're all in favor of that as well.
So the next matter I have is 56 Fairview Street. This household was served with a 30-day notice to quit for non-payment of rent back on October 23rd of 2020. At that time, they had an outstanding balance of $2,160.58. And they presently still have a balance through the end of February. They have been making some payments on the account. However, they still owe $2,036.37. And we're requesting that a certificate issue.
So, if I may, Madam Chair,
Sure, Brian.
some of these have been making progress and they're 2,000 or 1,200 or what have you. It seems like they're only inches apart from resolving an issue rather than letting it exasperate and get worse over time. There will be people that have arguments as to why that's the case, but so when I went through every single one of them, the ones that stuck out the most were the ones that were $1,200 at the time of the notice. And I'm just curious is it Tom Leanham? Is he not the representative for Hillcrest Properties?
He's the property manager.
Okay, so he's on the board too, right?
Well, he's not on the rent control board, no.
No,
Isn't there a property manager that is?
No, there is not.
There's nobody that represents Hillcrest on the board.
No.
Is that a requirement?
Well, in order to be on the rent control board, you need to be a resident of Rockland. And
Okay.
at the present time, they don't have anybody that's a resident of Rockland that would be able to sit on the board
Okay, all right.
as the
Thanks for
owner.
clarifying that. It's just when I hear these people that sound like they're really working hard to get so close, you know.
Well, some of them are. I mean, and
Yeah,
we're
and they
gonna-
could be very well resolved just by the fact they get in front of a magistrate and they work out some sort of payment plan to get.
payment
on
plan or just
track.
reach out to some of the agencies. I mean, they fluctuate. I mean, some of them, the balance is not big right now, but for example, back in December, the balance on this house was $6,000. You know, they made a big payment, but they haven't paid anything in the last 2 months.
Gotcha.
So
If I can comment, you know, this is Tom Lennon. This particular resident was successful in receiving raft funds. And this resident also understands the process. We have delivered countless letters, phone calls with explicit instructions on how to apply for raft and ERAP assistance. This person was successful. We don't know why this person is unsuccessful in clearing their balance. It could have something to do with reaching a limit or failure to proceed with asking for additional funds. And so this one could very likely, you know, be resolved, but we just don't know at this point.
Thank you. I guess what confuses me, amongst other things, is that there are supposed to be representatives for the owners, if you will, owners' representatives or managers, as well as resident representatives. And in Rockland, that would be 4, and then there are 3 representatives for the town of Rockland.
I can speak to that, Brian. There is another Rockland town bylaw that says you can't be a member of a board unless you're a resident. And we've candidly, that's been one of the challenges, finding either a hometown employee or a Hillcrest employee to serve as the owner's representative. That hasn't been easy. But they have to be a resident of the town because of a different bylaw. So that's the hang up.
Okay. So how do we get over that? Because we had an issue with the last meeting with a quorum, and it appeared as though we had one. It's just that there was obviously an appeal to recuse Casey at the time from the entire meeting. Never mind being able to function as a board member, which seemed a little strange. But that aside, you know, that leaves us not 1, but 2 members short on the committee. Is that not true? So we have 5. So we have all 5 members of the committee right now.
We have 1 owner's representative, Carol Primavera, who didn't make it tonight. Hopefully she makes it to the next meeting. So at least we'll start with 6. Even if 1 member had to recuse him or herself, we'd be down to 5, and we'd still, a quorum is 4, so we can still operate.
Right.
It's not ideal. The rent control board is very unusual in the fact that people who have interests are participating in matters that directly affect them. If you were on the planning board or zoning board, you couldn't participate in a matter that involved your neighborhood, but that's just how rent control is set up. It's a little different, but filling these slots has been a challenge. But as long as we get a quorum and we can move forward, I think, you know, then that's what we need to do.
Thank you.
So I think, Brian, to clarify, as far as I understand, the eviction notice that we're trying to put forward for this person, even though it is a low amount in relationship to some of the others, is to be able to get them before the housing court so that they can either continue with some of the programs that are there, if that's the case that they have been approved, or to work out some sort of a payment plan. Am I correct in understanding that, Mr. Laverty?
That is correct. That's the landlord's position. And the court's position as well right now is try to get them, like this tenant, even though they applied for raft monies, they can reapply for some additional monies. They can also reapply for some, what they call stipends moving forward to assist them with the rent going forward. If for some reason they don't qualify, then the landlord would offer the resident a payment plan, which would allow them to remain as long as they make certain payments. It's keep current with the rent and then make some payments every month toward the back rent till you catch up. So that's the landlord's position. But in order to do that, they need to initiate the eviction action in houses left.
Well, thank you both.
So I'll just go back to 56 Fairview Street. I would request that the board issue a certificate for this resident.
Is there anyone from 56 Fairview Street that would like to speak of this? No defense. Would someone like to make a motion to approve or disapprove?
I'll approve it, Deb.
Okay, and a second?
I'll second it.
Okay, all approved? Okay,
The next one that I have for the board is 27 Balsam Street. That household was served with a 30-day notice quick for non-payment of rent back on October 23rd of 2020. At that time, they had an outstanding balance of $1,908.44. Presently, through the end of February, they still have an outstanding balance of $12,848.71. And we're requesting that the board issue a certificate.
did you say 12,000?
Yes, $12,848.71 through the end of February.
Is there anyone from 27 Balsam Street that would like to speak of
Yes.
this?
We're not, it's not that we're
Could you
not
give-
paying the rent.
Could you give me your name and address, please?
Yes. 27 Balsam Street, Kayla Kozemski. And it's not that we're not paying the rent. If we weren't paying rent, I could understand a certificate of eviction, but I think you guys should deny it because we are withholding rent for a number of issues. One is they don't have the current lease in our name that we signed with Mark when he was here. I told Albert when they hired Albert about it. He said he was gonna fix it. He didn't. I told Tom the first day I met Tom about it. He said he was gonna look into it. Still haven't heard nothing about it. The eviction isn't even for the current residents. It's for the resident before us, which is a problem in its own. I have written more than one complaint about it, and that the fact that they don't have a current lease is on the complaint list. It's also my porch is falling off my house and sinking into the dirt. I have one of the older homes where the porch is not my responsibility. It's the responsibility of the parks. If I was to pull this out of here, the porch would not come with it. As well as my concrete slab is floating around all the edges. Even Tom has agreed that, you know, it is their responsibility and it would be fixed. Mark said the same thing back when he was here. Albert said the same thing. And it's been going on. The reason the rent is so high being withheld, because it's being withheld till the problem is fixed. And in the Attorney General, it says you are allowed to withhold your rent if there is a problem and you bring it up. And anything, any type of eviction notice that you get within 6 months of a complaint, you know, is retaliation. And we've gotten more than one eviction notice and the problem still isn't fixed. They are looking into it. They did. Tom was just here with an engineer last week, I believe. So it's not that they're not looking into it, but there's been a lot of looking into it and no fixing it. And I mean, I can go in front of a judge, but there should be no reason for me to be forced or brought in front of a judge to try to, you know, intimidate me into paying rent that shouldn't be paid until the problems are fixed.
Mr. Laverty, would you like to speak of that?
Sure, absolutely. So the landlord does acknowledge that they've complained about their the slab under the home. The landlord has been working on that. I have a report dated February 4th, and Mr. Lenahan can speak more about it, but the concrete slab itself is sound. There's no structural problems with it. There are some issues around the corners that the landlord anticipates that they will repair once the weather gets a little bit better to resolve this issue. So from my client's perspective, that, you know, the tenant has misquoted in Massachusetts, there's no such thing as a rent withholding statute. And it's my client's position, they have an obligation to pay the rent, just as my client acknowledges that they have under certain circumstances to make required repairs. I think this falls under that category. And my client acknowledges that they intend to make the repairs. But my client still has a right to move forward with this matter in housing court. That can always be a defense that the resident can bring up. It may be that we reach a resolution before we actually file this complaint in housing court. we're very close to making the repairs. But again, the only requirement for my client to seek a certificate of eviction from the rent control board is if they gave the proper notice and the tenant has not cured that notice to quit. So there was an appropriate notice to quit and there's still an outstanding balance. You don't necessarily need a lease agreement to create a tenancy. So that's also a misnomer. So my client's position, they have a right for a certificate of eviction and they are seeking that in this case. It may not.
So my porch being 3 inches away from my house now and falling onto the ground, and me being disabled and having to use a walker sometimes and could slide down it because it's at a slant, that's not a problem. That's not a reason to withhold my rent. That's not.
So my position is you don't have any legal basis to withhold the rent if the landlord is in the process of making some repairs, but that's for a housing court. That's not for the rent control board.
Madam Chair, if I could speak to this.
Certainly.
One of the difficulties we've had over the course of several years is that the rent control board has a very limited and narrow purview, and they have no ability to force a park owner to make the kind of repairs that this tenant is bringing up. What we've tried to steer people to do is to go to court, go to housing court, where there are housing advocates and people who can steer them in the right direction. And the court has the ability, if the repairs you're talking about are safety issues, health issues, the court has the ability to make the owners do things. But what we try to say is those kinds of issues need to be taken to someone who can actually do something about it. And the 6 volunteer members of the rent control board just don't have any ability to compel those kind of repairs and make those kinds of things happen. So it's a very narrow issue that's before the board. You know, did the park owner meet the notice requirement to the tenant? And the tenant, you know, by her own admission, hasn't paid. We're not unsympathetic to those things, but if you go to housing court, there are people there that will advocate for tenants. The reality in Massachusetts is the law very much favors tenants, and there are people there that will try to help you, but that's where you need to go.
Thank you. Tom, do you have anything that you would like to speak about this matter?
Well, yeah, I want to thank Kayla for us finally getting together. It's been at least 6 months that we've been attempting to get together, and we finally accomplished that. She allowed us into her home area to view the washout of the slabs, and you know, part of that washout is caused by the downspouts needing to be extended. But we will absolutely be proceeding once the weather gets adequate temperature-wise in order to make those repairs. As far as I'm aware of, there's no such law that states that we own a deck or are responsible for a deck. I was under the understanding that we rent the space, we rent the site. So I don't understand the claim there. You know, Mr. Laverty, perhaps if you know anything about that, or if we need to do research, that is something that I don't believe that we are responsible for.
It is in the Attorney General law. I don't have them in front of me right now, but I can find it and send it to you, Tom. But it does say any home before, I believe it's 2006, the park owns the porch. The house, it's not attached to the house because it's so old. So if we were to pull the house out, the porch is to stay, which is what makes it your responsibility. Like the house across the street from me, their porch is attached because they're a newer home. They would be responsible for their porch. Mine is not attached to my home because of how old the home is, and that's why it's your guys' responsibility.
Well, we certainly will look into that and get to the bottom of it. Whatever we're responsible for, obviously we need to take care of. But once again, thank you for allowing us in after many attempts to make an appointment, have the structural engineer prepare the report. We already have the gentleman that you met lined up to do the repairs. He is a HUD certified installer. And we will notify you of the date in which we will proceed with that.
Okay.
Tom, Brian Kane here. Real quickly, is Hillcrest in fact a HUD development?
Well, so the way I understand how HUD works, and Casey, I would defer to her. She seems to actually know a lot about this, but I know that the HUD law changed or was introduced in 2006, and I believe that new homes that came in after that point needed to be installed via the HUD certification. So old used homes don't necessarily apply to this HUD certification. So either Mark, if you have any information on that to share with us, or Casey.
And what you say, I believe, is correct, but there is zoning and I hate the term, but the grandfathering of things that were up to code in 1975 suddenly weren't in 1977 because they changed the building codes regarding lead. And in private home dwellings, so these codes and things change all the time. But I'm just was curious, mostly to know if that was a federally subsidized development to begin with.
It's not. It's not like a 55+ community. It's not federally subsidized. It's a licensed manufactured home community. But the HUD rules and regulations, they do change. And if they bring in any newer homes, they must comply.
Right. But don't those apply to HUD financed or HUD developments versus state developments? And I ask that because I built a building in Weymouth and we avoided working with HUD throughout the process to maintain working with the state and the state funding than getting involved with the federal government. So we didn't work with HUD at all. And it's all affordable housing. And
Yeah. Brian, I think basically the HUD for the manufactured homes is the process in which they're placed onto the slab, if I'm understanding correctly. I don't think it has anything to do necessarily with the finances or any sort of class.
or building codes or municipal codes and.
I'm not sure about the building codes as far as, because it does have to do with how the home is put in place on the property.
On the pads or whatever.
On the pads, is from my understanding.
Right.
And how the home is constructed itself.
Because I know going back to the 70s, they were described as trailer home parks. Literally, you could drive onto it and rent the space and stay. They weren't like Leisure Woods or let's say even Hillcrest, where they were brought in by tractor and dropped onto a frame with the wheels removed. The term goes back a long way, so there's a lot of different talk depending on what you read in cases, but I'll drop it right there. Thanks. Yeah.
So that
So,
brings me back to 27 Balsam Street, and I'm requesting that the board issue a certificate on this case.
do we have a motion to approve or disapprove?
I'll approve.
Do we have a second?
Second.
All in favor? Okay. So that was approved.
That brings me to the last certificate of eviction before the board, which is 31 Crestview Street. That home site was served with a notice to quit back on February 16th of 2021. At the time, the outstanding balance was $5,924.13. That was a 30-day notice to quit for non-payment of rent. No rent has been paid on that home site. The outstanding balance through the end of February is $14,368.65. And I'm requesting that the board issue a certificate on this case so that the landlord could initiate an action in the housing court.
Okay, do we have anyone from 31 Crestview Street?
Yes, that is us.
Hi, Casey.
Hi.
And would you like to say something on your behalf?
Yes, I would. Thank you. I would like to say that we have been withholding rent, which we have done so properly, which we are allowed to do in the state of Massachusetts, for several issues regarding not just our home itself, but the home site. Our home itself is installed and just put here illegally. It does not belong in Rockland. There are several wind zone issues regarding HUD, which everyone is aware of, the town, building department, health inspectors, management. Along with the slab itself, it does not fit the size of the home. There have been several issues with the home, which Hillcrest has had an engineer come out and look at the slab, and they had made their own decision stating that it was not their responsibility. I also had my own engineer come in for the exact same reason. And we are at a standstill right now. I have hired an attorney who is handling this situation, and I believe I would like for everyone to allow us to handle this outside the purview of the board. I don't think that based on what I've done and what they've done, it's not something that the rent control should really be too involved in. But again, that's up to the board. So.
Okay. Mr. Laverty, do you have anything?
Yeah, I'll just briefly summarize it. I actually don't disagree with Ms. Kidd. This is a matter that probably belongs in court. It's probably the only way that this case is going to get resolved. We've attempted to work with the Board of Health in Rockland and the building department in Rockland. Ms. Kidd does have an attorney who represents her. We've been informed of that. My client is also represented by counsel. We have engineering reports. I think the only way that this matter would get resolved in some form or fashion is if we initiate this case at housing court. And that's why we're asking that the board issue a certificate so that we can do that.
Okay, just to clarify. So if we approve this notice of eviction, that would be certain that she would be able to get her time in court with her attorney in housing court. Is that correct?
That is absolutely correct. So the landlord would file a complaint, and Ms. Kidd and her attorney could file an answer, defenses, counterclaims, whatever they wish. Absolutely. It's not a certificate of eviction that allows Ms. Kidd to get evicted. She has every right to defend herself with her attorney, with or without her attorney, and in housing court.
Okay.
Madam Chair, if I could, and Mr. Laverty, correct, there's also a third party involved in this thing who was involved in construction of the home.
That is correct. There's actually a third party who sold the home to Ms. Kidd. My client did not sell the home to Ms. Kidd. And I would anticipate if we bring this case, that person would be brought into this as well.
Okay.
So that the reason I mention that is because that makes it that much more appropriate that this go to court. We don't have any ability to interact with that third party, who's definitely going to be an important part of the resolution.
Okay. Sue, did you have something you wanted to say?
Yeah, as I understand it, our responsibility is simply to approve or not approve this certificate based on whether the process was followed properly so far. Am I correct?
That's correct.
Okay. Then I absolutely have sympathy for your situation, Casey. I'm not sure that there's much we can do about the way we need to vote, though.
Okay. So do we have a motion to approve or disapprove?
Regretfully, A motion to approve.
Okay. Do we have a second?
I'll second.
Okay, everyone in favor? Okay, so it's approved.
Before we go on, I have it in my notes that we voted a certificate for 61 Fairview. I'm looking at the documents, Attorney Laverty, and I'm seeing 62 Fairview, but not 61.
Yeah, I have it in my notes the same.
You're correct. I misspoke. It is 62 Fairview Street and not 61 Fairview Street.
I've asked the board to make a motion to rescind the vote on 61 and re-vote for 62.
Wait a minute, guys. It's 661 as far as I have.
I have a 62 in the notes that were sent over. Do we have a 61 as well?
Yeah, we do not have a 61. I'm sorry, we do not have a 62. That may have been a mistake.
So what I'll do for now, Madam Chairman, I'll withdraw that certificate of eviction and I'll look at it further to make sure we serve the appropriate home site with the proper documentation. But we'll withdraw that at this point, and if I need to proceed forward at a later date, we will do that.
Okay, so that is totally withdrawn.
Correct.
Okay. Do we need to vote on that?
No, I think
Okay.
so.
Okay.
So the next up is the petition for a rent increase. Attorney Laverty, I guess.
Yes, we were back in front of the board, I believe, on November 30th of 2021. We had presented our 2021 rent adjustment petition. It was for July 1st of 2021 through June 30th of 2022. We had submitted the annual registration statement, the rent roll, establishing the current rent at $672. The owner's petition for rent in accordance with the revised rent control rules and regulations that were revised on May 13th of 2014. We were seeking a CPI increase, and the increase was 0.4%, which equates to $2.64 per month, which would bring the total rent due as $674.60. So we had submitted that back on November 30th of 2021. However, the board chose to table that before they took a vote. It's the landlord's position at this point that the only way that the board can refuse to grant this upward adjustment in the rent is if they find there's a substantial deterioration or failure to perform ordinary repairs or maintenance at the Hillcrest community, and whether or not there's any outstanding Board of Health regulations or some sort of court order from the Housing Court or Superior Court, which it's my client's position. There are no outstanding violations. There are no code violations or any matters in Housing Court. So we would request that the board approve this increase and allow the landlord to move forward with a 0.4% CPI increase.
Is anyone aware of anyone other than what we just heard, aware of anything with any of the boards and complaints or anything in Housing Court? Okay, so do we have anyone that would like to speak of this from Hillcrest? I'd like to make a motion to approve or disapprove.
I'll make the motion.
To approve.
Second, to approve.
Okay.
To approve, yep.
All in favor? Okay. So it was approved.
Okay, so we have another meeting Friday evening to consider the Leisure Woods petition.
Correct.
I know Friday night is not anybody's best option, but that was the best we could do, unfortunately. So
Okay, so that's 5:30 Zoom.
that's correct.
Okay. All right, so do I have a motion to end the meeting?
A motion?
I'll second it.
Okay, so all in favor?
Aye.
Okay, I guess we're all set then.
Thank you,
Deb.
Thank you.
Thank you, everyone.
Thank you.
Good night.
All right,
Right.
take care.
Good night.
Casey.